It's the morning of October 25th, 2010. I'm Michael Aron of NJN News. We're at the Eagleton Institute of Politics at Rutgers University for the Rutgers program on the governor, the Brendan T. Byrne Archive. This morning we're going to talk to Stewart Pollock. Stewart was chief counsel in the first year of the second Byrne administration. He served a year and a half, and then Brendan Byrne nominated him to a seat on the state Supreme Court, where he served notably for many years, and we're going to hear about that. Justice, I said you had served on the court notably for many years, and you told me off camera 20 years. You also said they were the best years of your life?
Best years of the professional life, and maybe the best years of life in general. It was a wonderful experience, no matter how you look at it.
Well, let's go back some years. Where are you from?
Morris County. In fact, I've shown very little imagination in my life. I live now about half a mile from where I grew up.
Where is that? What town in Morris?
It's in Brookside, which is the eastern end of Mendham Township.
Why have you been there all your life?
Well, moved around a little bit in between the present house and where I grew up. But when I was in law school, I decided I did not want to practice in New York.
Where did you go to law school?
Pardon?
Where did you go to law school?
New York University. And so I knew I wanted to come back to New Jersey. And when we first came back, we lived in different places. When I was married while I was in law school, and the marital residence to which I took my bride was a used trailer in Bayonne, New Jersey. And then we jumped up to an apartment in Little Falls, and then a home in Madison. But I always had in mind getting back to Mendham Township. I've always loved it.
Where'd you go to high school?
Morristown High School. In those days, Morristown High School was a receiving district for a lot of communities. Morris Township, for which it is still the receiving district, Morris Plains, Mendham Township, Mendham Borough, Harding Township, Hanover Township, East Hanover Township. So the school that I went to in Brookside was a four-room school. We had 2 grades in a room, one teacher teaching everything to both grades. And then for high school, you went into the big city, into Morristown.
Where'd you go to college?
Hamilton College.
What'd your parents do?
Well, my dad was a salesman, and they were people of limited means, limited education, but they were terrific parents.
What ethnicity are you?
Well, my father is of Scottish descent, and my mother is of English descent. I mean, if you trace it back.
Did you have brothers or sisters?
I have an older brother and a younger sister.
What characterized you as a young man? What were your interests?
I'm not so sure. I've got a good answer to that question. I love baseball, and the best friend I had as a kid was my dog, and we grew up in this little town where there was, as I say, the school. There was a general store that had the post office in back, gas pumps in front. I worked there after school, and there was a community house which served as sort of a meeting place for the town, one church in town, and that was sort of a Norman Rockwell kind of life.
Why did you want to go to law school?
You know, I didn't, unlike a lot of people, I did not have a great compulsion to go into law. I wasn't quite sure what I was going to do when I left college. And the dean came up to me, the dean of the school came up to me in my senior year, asked what my plans were, and I told him I wasn't sure. I had been the chairman of the honor court in college, and he said, why don't you think about law school. Well, my education has always been financed largely through scholarships, and NYU had a terrific scholarship opportunity called the Root Tilden Scholarship, founded by Arthur T. Vanderbilt. And Vanderbilt was then the Chief Justice of New Jersey. He was an extraordinary man. He had been the President of the American Bar Association, political leader in Essex County, Dean of NYU, and a leading lawyer in New Jersey. He wanted to make NYU a national law school. So he founded this scholarship plan, and I applied, and I was lucky enough to get one. And so one of the tenets of the plan was that you should accept public office when offered. And so that was something I had in mind that I tried to fulfill as I went through the rest of my life.
What years were you in law school?
I was there from 54 to 57.
And then what did you do when you came out of law school?
Well, unsurprisingly, I joined Arthur T. Vanderbilt's former law firm, and which was, after he left to go on the court, the firm was known as Toner, Crowley, Walper, and Vanderbilt. The Vanderbilt's two twin sons were still there. And in those days, you had to clerk for 9 months before you could take the bar. So I clerked there for 9 months, took the bar, passed it, and I remember one day I was sitting in the library and Bill Vanderbilt, who was one of the chief's twin sons, came in and we got talking, and I asked him, how long do you think it'll be before I get to try a case? And he said, you mean in the Superior Court or U.S. District Court? And I said, yes. He said, probably 6 or 7 years. And that sounded like a long time to me. And Bill very kindly called down to the then U.S. Attorney. And I went down there for an interview, and a couple of months later started as an assistant U.S. Attorney, which I did for a couple of years. And then I went out to Morristown to practice law.
What kind of law did you practice?
Well, I started off trying cases. That's what I wanted to do. That's what a lot of young lawyers want to do. And as time went by, a couple of things happened, one of which was I got tired of waiting around in courthouses, waiting to be reached. And in the 1960s, just about that time, there was a change in the banking laws in New Jersey. And up until then, banks could only branch in the county where they had their principal office. So the Newark banks were confined to Essex County, so forth. And they were dying to get out into the suburbs where the growth was occurring. So initially the law was changed so that the state was divided into 3 districts. And the banks could then branch within those 3 districts. And as you might guess, as that happened, there were lots of contests about whether a new bank was needed, whether it was appropriate, and so forth. So the banks suddenly needed lawyers who had some experience trying cases, and I did a lot of that for several years. Then the law changed so that there could be, as there is now, statewide banking. And some of the banks that I'd represented in these contested hearings were kind enough to come back and ask me to represent them on mergers, acquisitions, and so forth. So I started to shift over into that area. And that's what I was doing when I met Brendan Byrne.
How'd you meet Brendan Byrne?
The first time I met him was at a course in continuing legal education at Harvard. And it would have been around 72, 73. I needed to get a grasp on securities law and antitrust law, which I really didn't know much about, but the banking acquisitions were raising issues concerning those areas of law. he had just been named the assignment judge for Morris, Sussex, and Warren counties. And he had been a prosecutor, but in the interim, he had gone on the Board of Public Utilities Commission as the president. And he wanted to get back up to speed on criminal law. So he was up at Harvard and taking a summer program, and he was studying criminal law while I was doing antitrust and securities law. And we met during a coffee break and had a nice chat. And then he indeed started that fall as the assignment judge, and the assignment judge for those 3 counties. Now it's down to 2 counties, Sussex and Morris, but in those days Warren was included. But the assignment judge sat generally in Morris, and I was the president of the Morris County Bar Association that year, and I tried some cases before him with a notable lack of success. But we got along. From the moment I met him, I liked him and respected him, which is something that continues down to today.
Was he a good judge? What kind of judge was he?
Yes, he was a good judge. He had a style of his own. What a lot of folks don't realize is just how keen his analytical mind is, and he could cut to the chase on an issue very fast. And he also, I just liked his demeanor and his personality. He could be, have that dry sense of humor that I just enjoyed. I remember trying a case. It was the last case he tried, and I remember I had worked with an expert for weeks preparing a lot of data. And we got through the first page, and he said, "Are you going to go through all of this stuff?" Well, I picked up the signal and said, "Oh no!" And that there's an interesting story attached to that. We tried this case for quite a while, and then one day it was a non-jury case. I was sitting in my office, which was about a block down the street from the Morris County Courthouse, when the phone call came from the judge's secretary, Amy Cadmus, and she said, "The judge is going to render a decision in your case today. He's leaving the bench." Well, I didn't know what was going on, but I raced up to the courthouse, and he handed out the decision, which he ruled against my client, and there were more reporters in the courthouse that day than normally. And I said, "What's going on?" And so what's going on is that the judge is resigning to run for governor. And he was very gracious when he handed the decision. He said, "Look, I ruled against you, but I've never seen a case tried better," which was consolation, small consolation, but I didn't go out empty-handed. And anyway, as I was leaving the courthouse, who should be walking down the steps alongside me but Judge Byrne? And he had this batch of papers in his hand. And I turned to him. I said, "Judge, you know I'm going to have to appeal this." He said, "I understand that." And I said, "Well, look, there's no hard feelings. Let me wish you the best of everything." And he had what he had in his hand was his petition to run for governor, and he held it up. He said, "I don't know how this is going to turn out." And the rest is history.
Had you gotten involved in politics at all during those years?
A little bit, and that when I first started out, one of the things that Vanderbilt wanted the Root Tilden scholars to do was to become active in public life. And I'm a Republican, so I became active in Republican politics in the county. And then, for family reasons, I had to stop that and a lot of other things to take care of some stuff that was going on within the family. So by the time I met Brendan Byrne, I was really not that active. But for, I don't know, 5, 6, 7 years I had been.
What did you do?
I was a county committeeman. I was active in the Young Republicans. And then I had, I never did tell former Chief Justice Hughes this, but I was the campaign manager for Jim Mitchell in Morris County when the Chief Justice Hughes ran the first time and soundly beat Jim Mitchell.
Huh. So you met Brendan Byrne around 72 or 73
Yes.
and had this experience with him right before he put in his petition to run for governor. Did you have any kind of a rooting interest in the election in 73?
You know, I really wasn't too focused on it. In the primary, I remember what he subsequently told me was that he said, you know, he had had a very active public life, and he always kind of hoped that someday he'd get a chance to run for governor. But it became apparent to him that he wasn't going to have the chance, and so he went on the Superior Court. And then that year, Governor Cahill had some serious problems with some of the folks in his administration that raised issues about public confidence in government and so forth. And I think the perception, in the Democratic Party was for that reason that Cahill would be a weak candidate, and there was a large number of candidates who wanted to run against him. But the party couldn't coalesce around any one of them. And then people began to realize there was this fellow, Brendan Byrne, who'd been the Essex County prosecutor, been the president of the Public Utilities Commission, was a Superior Court judge, had a wonderful reputation for integrity. And that's what I think led to people coming to him and suggesting that he might run for governor. And that's, I think, is what he did. What led him, he said, at a time when he thought it was never going to happen, it sort of fell in his lap.
So he got elected. He beat Charles Sandman, who had beaten Cahill in a primary, and he kind of waltzed to election in that first term and served for a term. What were you doing during those years?
Well, during the first year or so, I was practicing law, and then, I know what happened. I used to play more tennis than a rational person would play. And
what does that mean? How often?
A lot, a lot. And I used to play with a fellow named Bob Klein, who was married to a woman named Ann Klein, who had been one of the unsuccessful contestants in the Democratic primary that Brendan won. And one Saturday I played with Bob, and he said, why don't you and your wife come down for dinner tonight? So down we went, and Ann said, what are you doing on next week? And I said, well, on Monday I'm going down to file the briefs to appeal the decision of Governor Byrne when he was Judge Byrne in this case I mentioned earlier. So she said, well, that's funny because I'm being sworn in as the commissioner of, I think it was Human Services. Institutions and agencies. So I went down.
The predecessor of what is today Human Services.
Right. So I went over and filed my brief in which I had been very critical of the decision that Judge Byrne had rendered. And then went over to the State House, where I'd never been in the State House in my life. And I was standing in that big outside office for the ceremony to begin, where the governor was going to swear in Ann as the commissioner, and I felt this tap on my shoulder, and it was a state trooper, and he said, "The governor would like to see you." And my immediate reaction was there was some weasel in the appellate division who had called over and told him about the brief. And so I went in, and he said, "Remember all those speeches you used to give about lawyers having a duty to serve the public?" And I said, "Yes." He said, "Well, I'm going to give you the chance." And I said, "What do you mean?" He said, "Look," he said, "I have a problem." This is sort of a shortened version of the conversation. He said, "The legislature has just made the Board of Public Utilities full-time," and that was in response to the OPEC embargo. You may remember the odd-even gas lines and all that stuff. Anyway, he said it has to be bipartisan, and he said, "I have two people for whom I must find a place who had been actively supported me in the campaign." He said, "But I need somebody who's a Republican, who's a lawyer, and who I can trust." And I said to him, I said, "Governor, I don't know the first thing about public utilities." And he said, either did I when I became president of the commission. So my kids were lined up for college at that time, and in the back of my mind was this condition of the scholarship that you should accept public office when offered. So we went back and talked it out within the family, and I said, "Look, I can give you 2 years, and I've got to get back to private practice because I've got to put these kids through college." And he said, "That'll be enough to get it started." And that's what we did.
Was it a full-time job?
That was a full-time job at a significantly reduced income. And so I went down for 2 years. And then I left, went back to private practice. And that's what I thought I was going to do for the rest of my life.
What exactly was the job that he gave you? What?
It was a commissioner on the Board of Public Utilities.
Oh, okay.
Yeah,
Okay.
yeah.
I misunderstood.
No.
I thought it was some advisory board.
No.
He made you a BPU commissioner.
Yes, yeah.
What years?
It would have been 74 to 76, I think.
And it served in Trenton in those days or in Newark?
In Newark.
In Newark.
Yeah, yeah.
And how was that experience?
It was terrific. As soon as the governor made the announcement, I received calls from an unlimited number of friends telling me I had made the worst decision of my life. And the reason was they said I wasn't going to be able to get along with the other two commissioners, who were former Senator Grossi from Passaic County and Joel Jacobson, who had been the head of the UAW. Well, they couldn't have been more wrong. Joel became one of the closest friends I ever made in my adult life, and we had a terrific experience. And the other big thing was that it took me out of the mold of just being a lawyer, as important as that may be, and I suddenly had to look at things from a different perspective. I had to learn about economics. I had to learn about government. And I had to learn something about politics. It was a great eye-opening experience.
You were there during the fight over the income tax.
Yes.
What was your view of Burns' problems getting an income tax passed?
Well, you know, the governor, what I remember was in the summer of, must have been the summer of 74 or 75. We got a call from Trenton saying they wanted everybody, all members of the cabinet, to come down for the legislative session because they were trying to marshal votes, and so I remember going down to the State House in the summer trying to talk to the legislators from Morris County about why they should vote for an income tax sponsored by a Democratic governor. I don't think I was a very effective salesman.
Do you remember any of the people that you spoke to? Remember any of the delegation?
I just can't remember. I think the senators at that time may have been Freeland. I think the legislators. I'm hazy.
It took about 3 years to get that
Right.
bill finally through.
Right.
Were you behind it all the way?
Yes. I mean, I felt once I signed on for the administration, I was there, and I also thought it was right.
You say you offered to serve 2 years. When the 2 years were up, did you step aside?
Yeah, essentially. It took a little more than 2 years before the governor found a replacement, and I wanted to stay until he found a replacement. And then I went back to private practice, and he initially called and suggested that I become the chairman of the board at UMDNJ. And I went on the board with that idea. The fellow who was the chairman, he was an executive at Prudential, and he had served his time, and they needed a new chairman. But before I actually started, I got another call, and the governor suggested that I go on the State Commission of Investigation, and that's what I did from 76 to 78, roughly.
During that time, Byrne stood for re-election. Did you think he would get re-elected?
Well, I know the polls were against him. He was so. As you may recall, there were a lot of Democrats running against him in the primary. They thought he was weak, and I'm not so sure. I thought that I knew what was going to turn out. But what did become apparent to me in the course of the campaign was that he so conducted himself that I thought he certainly deserved to be reelected. I mean that he took a lot of courageous stands, and the people responded to it.
Did you support him?
I couldn't. I was banned by the members of the SCI can't be politically active.
What did the SCI do at that point in time? It was a fairly new organization, right?
Well,
6 years old, 7 years old.
Something like that, because Bill Highland had been the first chairman. When I was there, our job consisted of it's a legislative investigative commission which sort of defines what you do, but we looked at corruption, inappropriate conduct by public officials, primarily at the county and local level, although we were authorized to do it at the state level. We had responsibility for keeping track of the mafia, which had been one of the initial driving forces for the creation of the SCI. And we also looked into the formation of the casino industry in the wake of the Casino Control Act.
And this was a voluntary position?
It was part-time.
But it was paid?
Paid, yeah.
Byrne won the election. Do you remember why? As you look back on it, why did he win re-election even though the polls suggested he might not, and that he was weak at the beginning of that year?
The theme that they always played at the rallies during the election was from Rocky, and I think that caught on with the people of New Jersey, that this was a man. You might not like everything he did, but he stood up for what he believed, and he was courageous, he was honest, and I think the public responded to that. The other thing that came out was, I remember Ray Bateman, who was a good friend of the governor's and a wonderful public official, and Bill Simon, who was the former Secretary of the Treasury, came out shortly after Labor Day with something called the Bateman-Simon Plan, which undertook to point out why the income tax was not necessary and how the state could fund its financial problems through other taxes and growth. And it was a poorly conceived document from two such intelligent, respectable people. I don't know who drafted it. Anyway, what I remember was Brendan Byrne was coming to Morris County the day after that came out for a campaign session. And I read in the paper the next day that when the press asked him for his reaction to the Bateman-Simon Plan, he said, by the end of the day, it'll be known only by its initials.
Did you have any social contact with Byrne
It was
over the years?
Yes, it was
over those years before you became counsel.
Yes, I think that. Yeah, yes, it was mainly based on tennis and paddle tennis and squash, and we played in some tournaments together. we got into the finals of one, and I think we probably were the two most tired guys in the tournament by the end. But we developed a friendship while I was on the BPU, and it just kept growing.
How often did you play a racket sport with him?
Well, when I was counsel, it was a lot because he always liked to get exercise, as did I, and so we would go up to the Trenton Club and play squash, and then get a bowl of pea soup or something. We would play a lot of tennis at Morven, and he did a lot of business on the tennis court. I mean, I think he understood that if you could get somebody whose help you needed or support you needed, if you could get them out of a formal governmental context where you were wearing suits and sitting down in the State House and get them into a relaxed environment, you might make a little more progress than you would in a strict business setting. So we did a lot of that.
Under what circumstances did you become chief counsel?
It was not planned. It was serendipity again. During this period between leaving the BPU and going down as counsel, when I went back to private practice, my practice took off and did very well. That Christmas,
because you had been on the BPU. Because you had been on the BPU, or by chance.
I think it doesn't hurt for people to understand you're a friend of the governor's, and people would come in, and the business just came in from all over, and But I remember at Christmas time, it must have been Christmas of '77, I went to a party in Mendham where Bob Mulcahy was. And Bob came up to me, and Bob had been named the chief of staff for the governor. And he said, you know, the governor wants to bring in a whole new team. And how would you feel about coming down as counsel? And I said, I don't know, I'd have to think about it because I had these kids to educate.
How many kids?
4. And Wendy, our oldest, was already in college, and Stu, the second one, was about to go, and so forth. So a couple of days later, the phone rang, and it was the governor, and he said, how about coming down so we can have a chat? And I think I understood as soon as I said yes, the die was cast.
Did he say what position?
No,
on the phone?
and he didn't. And he was very.
But you knew.
When I got down there, what he said was, he said, you know, I had a lot of problems my first term. He said, I want to bring in a new team. How would you feel about becoming counsel? And I thought maybe he had me mixed up with somebody else because I was a registered Republican, and the council is, you know, an intimate part of the governor's team and so forth. So I said to him, Governor, I said, you may have forgotten that that I'm a Republican. And then there was a pregnant silence, and then a typical Brendan Byrne response. He said, well, I can stand it if you can. So, you know, and I just kind of melted.
What does the council do?
Well, I think it varies from administration to administration and governor to governor. Look, this is over 3 decades ago, but to the extent that I can remember, we helped formulate the legislative agenda. We helped implement it with the legislature, although there were 2 very experienced people who knew a lot more about democratic politics than I did, who were there, Bob Mulcahy and Harold Hodes. So the first part was the legislative agenda. The second was sort of being the governor's point man with the departments, particularly in my case with the regulatory agencies, because I'd been down that road through the BPU. And then there's all the helping put out all the fires that arise every day in an administration. And if I had to pick a 4th thing, it would probably just be being a backboard for the governor to bounce things off of.
What surprised you about the council's role that you may not have expected?
You know, I really didn't have a lot of surprises. I had worked closely with one of the assistant counsel while I was on the BPU. The governor called up one day while I was on the BPU and said, some folks are advocating a public utilities authority funded with public financing. And he said, I'd like you to take a look at it. So I formed a little committee of, you know, from the public defenders, rate council, utility executives. I think I had some academicians on it, and we looked at public power. And I filed a report, but I worked closely with one of the assistant counsel, and that gave me a pretty good idea of how the counsel's office functioned with Brendan Byrne. And we came out with a report. So when I went down, I think I had a pretty good understanding of what the council did I would say the most striking characteristic of the job, from my perspective, was it never ended, and it was exhausting. I was living in Mendham Township and driving to Trenton every day.
Personally, or someone drove you?
Interesting point, because one of the previous council had been criticized for having a driver. So I decided I was not going to have a driver. And there were times when I left the State House late at night when I would get between Trenton or Flemington and Somerville. I just didn't know where I was. And I thought to myself, this is bad news. So I called Rutgers, and Rutgers Law School, and said, look, I want, if you send me a qualified law student, I will get him into as many meetings as I can, but what I'm really looking for is somebody help me drive when I'm too tired to drive. And Rutgers said fine, and the next thing I knew, they said they were sending a student down. Well, in walked this very wispy woman, and I had just assumed that it was going to be a man. So I was dead wrong. Well, anyway, her name was Stephanie Lynn. She's later married a fellow named David Mills, and they live in California. And Stephanie served that function, and I got her into a lot of meetings. She did a lot of the driving, and she became my first law clerk when I went on the court.
How did the council's role differ from that of a lawyer in private practice?
Well, I'll start out with a point of similarity rather than of difference. My approach when I went down there was I was a lawyer with one client, and that was the governor. So I owed him all of my loyalty, and that was key because, as I later explained to Peter Venero when he was offered the position of becoming counsel, I said, Peter, you've got to be prepared to fall on your sword. That's part of the counsel's job. But going back to the differences, the biggest difference is the intellectual differences, I think. You're dealing with problems of public policy, certainly unlike those that I had dealt with in my practice.
More interesting then?
Oh, yes.
More challenging?
Yes, and more fun. Yeah.
So being a lawyer in the governor's office is more fun than being a lawyer in private practice.
It was for me, and I loved being a private practitioner, but there is something special about governmental service.
What was the structure of the governor's office at the beginning of the second term?
Well, we had Bob Mulcahy was the chief of staff. Don Linke became the first head of public policy. Shortly after we started, Harold Hodis came in as the deputy chief of staff. And then there were a lot of carryovers in cabinet positions, but some new people showed up. Dan O'Hearn, for instance, and so forth.
Who did you succeed as counsel?
I succeeded John Degnan. John had been the governor's chief counsel. He became attorney general, and that's the way that worked.
What issues did you work on in memory? What was the biggest issue you worked on as counsel?
Well, this is, as I say, it was over 30 years ago, but the ones I remember, the biggest one, I think, was the Pinelands. But then the governor explained when I talked with him, he said there were a lot of things I wanted to get through the first term and didn't. And one of those was the Office of Administrative Law, with the administrative law judges.
Had there not been an Office of had there been no administrative law judges up to that point in time?
Well, no, the way the system worked until then was that each department had its own hearing officers. And we had those at the BPU, for instance. And I think what I had supported the Office of Administrative Law during the first term. At that time, I was also a trustee of the State Bar Association. And the governor had tried to get through the act for the Office of Administrative Law the first term and couldn't get the votes. But I remember going down to testify at a legislative hearing in support of it on behalf of the State Bar. And when it came in the second time, we got it through committee. And I'm going to give you a somewhat modified version of what happened, but for whatever reason, the President of the Senate, Joe Merlino, didn't want to post the bill. And I remember walking into the Senate chamber and on the day that it was on the calendar, but he wasn't going to post it. So I said, Joe, what's the problem? He said, I'm not going to post this bill. So I figured, well, maybe somebody who had better connections in the Democratic Party would be more successful than I. So I spoke to Bob Mulcahy, and Bob went and spoke with Joe, and nope, not going to post it. So in came Harold Hodis, and Harold went up and spoke with Joe, and the next thing I know, I saw the number of the bill going up on the board. And Harold had delivered a message to Joe of unmistakable import that inspired him to put the bill up. But so it went up.
What was the message, do you think?
I'd have to clean it up a little bit.
Go ahead, clean it up.
It was to the effect that if he didn't post the bill, there weren't going to be any more jobs for his friends.
All right, I guess that works. Take a break? You want to, before we take it, how are we doing on tape? 10 more minutes? Let's go for a few minutes. You told two stories before we started rolling tape that I wanted to make sure we don't lose because they were good ones. One involved a meeting you attended with a lot of corporate CEOs. Can you recall that?
I do. When the governor ran for re-election, a lot of the corporations in New Jersey backed Ray Bateman, his opponent. And the governor, to his credit, realized that in order to govern effectively, he had to reach out to them and establish a relationship even though they had opposed him. And one of the people who came in was either the CEO or a top executive from Campbell's Soup who had a list of things that he thought the administration had gotten wrong. And he was running through this list, and he got to about the third item, and the governor looked at him and said, "You put too many tomatoes in your soup." And the fellow looked up. He said, "What do you mean?" He said, "You're telling me what's wrong with my government. I'm telling you what's wrong with your soup."
Did it disarm him, and was it a productive comment, do you think?
It was a good icebreaker.
The other story you told involved casino gambling, an issue I imagine as counsel you were involved with since it was the first year or two of casino gambling.
Right.
You took a trip with the governor?
We did. There was pressure to get a casino open, and Resorts International was the first one that actually got a temporary license. And I remember one of the first things we did when I went down as counsel was get through the temporary licensing legislation, and then resorts got the first temporary license, and the governor said, you know, we better find out how these things really work. And so he and I went out to Las Vegas and visited several casinos, and the casinos, of course, wanted to make sure that he was happy. So they said, well, what do you want to do? And he said, what I'd like to do is follow a dollar from the moment it's bet to the moment it gets in the bank. And it was just further proof to me that he had not only a grasp of the intellectual principles that you need to govern, but he also understood the nuts and bolts, because there's an awful lot of money that can fall off a table at a casino. And so I remember we got up into the ceiling of the in the eye in the sky, they call it, at the casino, where you can look down and actually see what's going on at the different tables. And another thing that happened was the initial casinos were largely renovated old hotels in Jersey City. And
in Atlantic City?
In Atlantic City, yeah. And so when a casino was about to open, we would go down and visit it. Well, the governor had developed, let me back off. On several of these visits, the governor asked if they could open the windows, because he wanted to make sure they weren't fire traps. And I remember we went down to one of the hotels, and the head of the casino, the first thing he did was run over to a window. Look, he said, the windows go up. But that was his. I mean, he had this ability to cut, as I say, cut to the chase, get to the core of an issue. He was concerned about safety, and he wanted to make sure the windows worked.
How did you personally feel about casino gambling in New Jersey?
Well, when it came up the first time, that was when I was on the BPU, and the governor asked at a cabinet meeting, is there anybody here who was opposed to casino gambling? And I said that I was. I can't remember who else so indicated, but there were one or two. And the governor said, well, that's okay, Gene's opposed to them too. And
Gene, his wife?
Was his wife. And but then, as I say, once I signed on as counsel, I felt my job was to implement his policies, and that's what we did.
Justice, you spent a year and a half as counsel. How often would you meet with Governor Byrne?
Well, a lot. I mean, I can't say daily because sometimes our schedules would take us in different directions, but it was constant interaction. We did have one fairly fixed schedule, and that was on Friday mornings. I would go to Morven, and I would sit down with whatever the big issues were that we had dealt with that week, and we would talk about them starting around 8:30, and go.
The inner circle?
No, it was just the governor and me.
Just the governor and you.
Yeah, and we would go through this, and then we would take a break and either go, after several hours, go hit some squash balls over at the Princeton gym or play tennis or whatever.
Mixing business and pleasure.
It was. He made it all fun. He really did. There was one time I remember when I can't remember what I had to do, but I had to be in Princeton late at night. And he said, why don't you stay at Morven? And of course the Morven rooms were all filled with members of the Byrne family, but there was a building behind it which was appropriately known as the slave quarters. That was where I spent the night.
Was it worthy of a slave or better than that?
Oh, I slept well, I know that.
What was Byrne like in meetings?
Well, he had a style of his own, and I think it varied from meeting to meeting. There were some meetings where he was fully prepared. There were other meetings where he relied on his ability to pick up the main points as they progressed. I think that's the way he was. I mean, I think in the second term he was, quite understandably, he was confident in his ability to govern, and he understood, what he had to do to achieve what he wanted to do.
To what extent was it a heady time, a heady experience?
It was a lot. It was fun. It was exhausting, and it was fun. One of his signature accomplishment was the Pine Lands, and that brought together a lot of different considerations. And if you want me to, I can.
Please do.
In answer to your question, I can go through that. The governor was concerned about the pine barrens being chewed up by development, and he became increasingly convinced that unless he did something, the pine lands would be eroded, destroyed, whatever. And so he came up with the idea of an executive order to ban building in the pine lands. And there were problems with that, due process problems. I know Dan O'Hearn, who was then the commissioner at DEP, was very concerned that we build into the executive order sufficient due process protections. And the real solution, we always thought, was with the legislature, that the legislature had to enact legislation in order for the pine lands to be protected over time. The problem was that there were conflicting constituencies in the legislature. The developers, builders who wanted to continue building and so forth. So the legislature was having a hard time acting. It was, to some extent, paralyzed. My recollection is that the Pine Lands Act was an administration bill, which means that it was prepared in the council's office, but then it gets introduced by somebody and works its way through the legislative process. But because that process wasn't moving, we had to do something. So the governor signed an executive order banning building in the pine lands, and that precipitated quite a strong response from building community and so forth. To me, it was his finest hour because he had to work with three branches of government: the executive branch, the legislative branch, and with the judicial branch, because an action was brought to challenge the constitutionality of the executive order. That was a heady experience, to use your phrase. The matter came on for argument before the court, and
trial court or Supreme Court?
It was brought. I think what happened was it went into the trial court, and then it was certified directly by the Supreme Court, so it bypassed the appellate division. And the it was a huge hot potato in all three branches. And I since learned, I don't know the details of this because I made a point of keeping myself ignorant of them, but I've learned that the court was divided, the Supreme Court was divided in how it was going to decide the case. And I don't know anything more than that. But what happened was, while the matter was pending before the Supreme Court, the legislature adopted the Pinelands Act, which rendered moot the executive order. And Byrne was quite confident that he ultimately was going to prevail because the public and the press were with him. And that ultimately is what happened. But the great part to see was an executive order to stop the building, working with the legislature to get the needed legislation through, and arguing, if not successfully, without a defeat before the Supreme Court.
Had you been on the court at that time, how do you think you would have ruled?
Tough question. I hope that I would have found a way to sustain the order.
What do you think lay behind or provoked Governor Byrne's deep interest in the Pine Barrens?
I think part of it was John McPhee, who wrote a book about the Pinelands. And John McPhee was part of the folks who played tennis at Morven. And I think he stimulated the governor's interest in this. I remember while I was at the BPU, John McPhee had raised a question with the governor. McPhee had written an article, I think, for the New Yorker. He was in the process of writing it, about a man up in Maine who was making handmade birch bark canoes. But he was getting the birch bark on somebody else's property. So he was taking somebody else's birch bark and building these canoes. And I remember the governor called and he said, "Listen, what do you think about this fellow's right to keep the canoes once he takes the birch bark of somebody else and builds it into a canoe?" So I did some research, and there is a doctrine in the law of conversion which says that even if you take somebody else's property, if you convert it through your own efforts into something far more valuable, you can keep it. So I said, I think he may be all right, but it's not a good practice.
That doctrine sounds kind of strange to me.
Well,
if you steal somebody's money but invest it wisely, you can keep the proceeds.
Yeah, well, it may have its limits.
Let's talk about your appointment to the state Supreme Court. How did it come about?
Well, what I remember was Dottie Seltzer, who was the governor's secretary, calling over one day when I was in the counsel's office. As you walk into the State House, the counsel's office, at least in those days, was on the left. The governor's office was on the right.
Still is.
Okay. Well, Dottie said, the governor wants to see you. So I went across the hall, and he handed me a piece of paper, and he said, "You better fill this out." And I looked at it, and it was the judicial questionnaire. And I said, "Why?" He said, "Because I'm going to put you on the Supreme Court."
Who retired?
Worrell Mountain.
Reached mandatory retirement age?
Yes, he was at 70.
Everybody knew that was coming. Was it an appointment you had thought about or asked for or projected yourself into? Or?
There was no way you can project, at least I think no way properly you can project yourself into that. But while I was there in counsel's office, I think the press became aware that not only was Worrell Mountain going to reach mandatory retirement age, but so was Dick Hughes. So the press, I think, was on to the notion there'd be 2 Supreme Court appointments coming up. And they were kind enough to suggest that I might be an appropriate person.
Did O'Hearn get the other appointment?
No, Robert Wilentz.
Wilentz got the other
Yeah,
appointment.
yeah.
Did O'Hearn go on the bench after you?
Yeah, Dan became counsel after me, and then he came on the court when Mark Sullivan retired, I don't know, a year and a half, 2 years later or so.
As counsel, had you had contact with the court? Had you had interactions with the court?
To some minor extent. The Chief Justice would call up now and then with some questions, and I, because the Chief Justice had been a former governor, I was inclined to answer his questions. I remember one time he asked me over to his chambers. I can't recall the issue, but what I do remember was sitting opposite the Chief Justice, and he had on a white shirt, and underneath it was a T-shirt that said "Candy is dandy."
Funny what we remember years later. Well, was that unusual? That a governor that a Chief Justice would phone the governor's top lawyer?
Well, sort of. I mean, the branches of government are not watertight, but it is important, to maintain the independence of the branches. So it's a balancing act, and when you get calls like that, you just consider all the surrounding circumstances and decide whether you can answer it or not, and do the best you can.
Did Brendan Byrne ever indicate to you that if the Chief Justice calls, by all means talk to him, or do you think you made that decision on your own?
He didn't have to make that suggestion. I remember, I'll tell you, I can remember a reverse situation. One of the things that I think, one of the distinctive characteristics of Brendan Byrne was I think he took judicial and prosecutorial appointments more seriously than any other governor has since. And there was a judge, I believe from Hunterdon County, who came up for reappointment. And he had received bad reviews on his demeanor. Nothing wrong with his intellect, nothing wrong with his work habits, but because the governor had been a Superior Court judge, he took very seriously appointments and reappointments. And when the evaluations came in on this judge, the governor decided he was not going to reappoint him. And so I'll have to back up a little bit on that. One of the things the governor did, he initiated a practice of having an independent person review potential judicial candidates. The first person was Alec Waugh, who was a highly respected judge, trial judge, who had been the assignment judge in Essex and in Morris before the governor. Anyway, that expanded over time till it became a judicial advisory panel, which still exists in the present administration. But I remember when the governor decided not to reappoint this particular judge, he said, I directly and personally why I'm not reappointing him, which, that was the governor's style, not to duck the tough issues. So the governor and I met with this judge in Morven on a Friday morning. And I remember when it was over, it was a very emotional meeting. When it was over, I remember saying to the governor, there's got to be a better way than to let somebody get to the point where he's up for reappointment to find out that he has a bad judicial demeanor. And so the governor said, well, why don't you call Dick Hughes and see if they can start some kind of evaluation process. So I did. I called Chief Justice Hughes, and he asked Alan Handler to take the lead, and they now have a fine process within the judiciary for the evaluation of judges as they progress through their initial 7-year term. So the judges, after they've been on the bench for a year or two, get feedback from lawyers, litigants, other groups about how they're doing, and they can adjust their behavior accordingly.
Do you think that that dismissal was justified?
Yes.
Your own appointment, how did you view it? The crowning achievement of a career to that point?
Well, I think, I can't say every lawyer, but a lot of lawyers dream about that happening. And it certainly was the zenith of my professional career. There was a stark difference between being in the counsel's office, where every day was like the gunfight at the OK Corral, and going on the court, where the highlight of the day was the afternoon mail. I mean, it's just a totally different set of circumstances. The court's work is contemplative, reflective, and the work in the counsel's office was reactive and often spontaneously reactive, where you just don't have time to research things. On the court, you try to research things as thoroughly as possible, think of all the possible consequences of a decision, and write an opinion that meets the needs.
Whose appointment came first, Willence's or yours?
Mine. I came up in June. The nominations were simultaneous. They were made on the same day. But I was sworn in June when Worrell Mountain retired, and Robert was sworn in, I think, in August or September when the Chief Justice retired.
And you would go on to spend 20 years on
Yes.
the state Supreme Court.
Yes.
So you were 50 when you were appointed, or 51
Well, I
or
didn't.
49?
Actually, I think I was 46 because I left.
Oh, you left
I
prematurely.
left 2 years early. Yeah, 2 or 3 years early. Yeah.
What was your view of Robert Willence?
He was courageous. He was intelligent. He was dedicated. And he brought it. I think to me, his most striking characteristic was his intensity. You would not want to steal his bicycle.
Did you generally agree with him on legal questions?
I've never looked at it that way, but we agreed a lot, and occasionally we disagreed. But that was true of all the members of the court. I often thought that a computer would have a nervous breakdown trying to analyze the demographics of the voting blocks on the court because they kept shifting. There was not a Republican bloc and a Democratic bloc. Votes shifted from case to case.
Was Worrell Mountain a Republican?
Yes.
So it was thought of as a Republican seat?
Yep.
And so Byrne needed a Republican, and
Right.
You were probably the most trusted Republican within his view.
Well, I know he looked at other candidates, but I'm delighted and honored that he ended up with me.
What do you think about that system of party seats, as it were, on the Supreme Court? It's an unwritten tradition, is it not?
It is. It's an unwritten tradition. I think it's worth preserving because it assures that neither of the two major political parties will dominate the court. On the present court, I think there is at least one independent. So I think on the present court it's 3 and 3 and 1.
I think you're right. Unless it was 4 and 2 and 1 for a brief period of time.
Could be.
Yeah.
Could be.
What were the biggest cases in your 20 years? The couple that were most high profile.
Well, I mean, for the court, I think the two classes of cases that were by far the most important were the school finance cases, the Robinson Cahill, Abbott Burke cases, and the Mount Laurel cases. They were the two most controversial cases. But you know, the court, that was not all the court did.
Were you in the majority most times on those issues, or?
No, I did not dissent in any of those cases. The court had a tendency, at least so it seemed to me, when it was at risk as an institution to try to work out our differences internally so we could speak with one voice. And no one was ever asked to sacrifice principles, but it just was the idea that in those cases, generally the court we tried to work out our differences internally so we would present a unified front to the public.
And to this day, 25 years later, give or take a few years, those are still the most contentious cases to come out of the modern Supreme Court, and are used as examples number 1 and 2 by critics of the court who feel that the court overreached in those cases or legislated from the bench. Your reply?
I think we had tough issues, and we handled them the best we could. So I'll stand by those opinions.
When the Constitution is unclear on something, is this an instance of the court clarifying the Constitution?
Well, I think in both sets of cases, it was, and the litigants presented the court with constitutional issues that required the court to make original interpretations of the Constitution. The school finance cases were originally started under both the state and federal Constitution as equal protection cases. While the first Robinson case was pending before the court, the U.S. Supreme Court said that there was no U.S. constitutional right of equal protection that required more adequate funding of poorer districts. The Weintraub Court looked at that, and this is where the genius of Chief Justice Weintraub comes in. He said we're not going to look at this as an equal protection issue. We're going to look at it as a thorough and efficient education issue. And so that was an original, creative construction, but that formed the framework for which the under which the analysis has proceeded over the last close to 40 years. Yeah. So to that extent, there was a sort of creative interpretation of the Constitution. And similarly with the Mount Laurel decision, that came up under the General Welfare Clause of the Constitution, and the court interpreted that so that you could not have exclusionary zoning that zoned out poor people, and have it consistent with the General Welfare Clause.
And again, the critics would say that's an activist court.
Well, sometimes you have to live with criticism in public office.
In retrospect, are there any different remedies that would have worked better in Robinson or Mount Laurel? For example, mandating statewide or countywide school districts rather than focusing on money and the amount of aid to Abbott districts.
Well, I think one of the problems with both cases, and one that troubled me as the court progressed with both sets of cases, was not entering an order that you couldn't enforce. And the question occurs, let's suppose the court had entered an order like that, and the legislature or the local officials said, thank you very much, we're not going to do it. What does the court do next? And that was something, as we progressed with both sets of cases, the inability of the court to enforce its decisions is something that troubled me more and more. So I think there were alternatives. There were things I know in Mount Laurel too that we talked about that ultimately did not find their way into the opinion. And I know at least one other member of the court shared my concern that the court might be putting itself in a position where it would be entering an order that it could not enforce.
Did the court get into difficulty in specifying details of school performance?
Well, you know, that was an issue that surfaced, if my recollection is correct, under the Abbott-Burke cases, and it was presented to us, and so we had to consider it. And in the school finance cases, we said all along that the other two branches are better able to solve this than we are, and ultimately the solution will have to come from a legislative or an executive solution. So I think, yeah, there were problems in adopting standards, but that was one of the alternatives that the administration that presented to us in the form of legislation, so you have to consider it.
The current governor is openly critical of those decisions. Does that depress you?
No. I mean, he's, as the governor, like every other citizen, he's certainly entitled to his opinion. So,
Your In one of your notes setting up this meeting, you referred to the right to die and Baby M decisions of the 80s. Do those stand out as landmark decisions?
Yes, they are.
Tell us about each of those.
The original decision came before I joined the court, the Karen Ann Quinlan decision, but we had at least 4 right to die cases while I was there. There may have been more than that, but I can recall 4. And then, of course, we had the Baby M case. And the interesting thing about those was that they implicated not just legal principles, but ethical concerns, and the court in those tried to come up with a solution that would provide the best system for people to make these very intimate and personal decisions about whether to die, whether a relative should die, and so forth.
Those are difficult issues for a court to address, I would imagine.
Well, they are, and the approach we took was that these are really decisions that are better made by other actors, by families in consultation with their physicians and religious and ethical advisors.
But I think in the Baby M decision, the court asserted that surrogate motherhood was wrong. Is that not the case?
Well, the interesting thing about that case was that there was no readily identifiable principle that helped decide it. So the court turned to the laws of the statutory laws of adoption and the best interests of the child, and we concluded that the best interests were not to terminate the parental rights of the surrogate mother, but to award custody to the I think their name was Stern, and but allow visitation rights and so forth.
This was a case where the mother decided, after having contractually agreed to provide the child, that she wanted to keep the child. Is that correct?
Yes, that's what happened, and one side was saying, look, a contract's a contract, and this is the contract you made. And we said, no, that's not the way we're going to look at it. We're going to take a look at the related areas, like the adoption statutes, and make the best interest of the child our dominant consideration. I think Baby M is now probably in her 20s, and I've heard that she is a happy, well-adjusted young lady. So at least I certainly hope so.
How about the death penalty? The court famously never reviewed a capital case in a way that ended up in an execution. It always remanded or overturned. What's your recollection of those cases?
They were the most difficult cases we had. As one of the members of the court once said, I didn't become a judge to kill people. And I think, from my perspective, I never liked the death penalty. I thought it was a ill-conceived legislative solution, but I thought the legislature, within constitutional limits, had a right to a death penalty if that's what it wanted. So that was the sort of the way I went forward. I didn't like it myself, but I recognized that the legislature had the right to establish that as the policy of the state.
So did you vote for some executions, but you were in the minority?
Well, I never voted for an execution where I was in the minority, but I did vote for some where I was in the majority. You know, let me just switch back, if I may, to the earlier part of this interview, because what I'm about to say, I think, tells a great deal about Governor Byrne. As the prosecutor in Essex County, he had personally tried, I believe, 11 death penalty cases, and that resulted in convictions and the imposition of the death penalty. He strongly disliked and did not believe in the death penalty. And when I remember that while I was counsel, the legislature reenacted the death penalty. And he said, I want you to draw a veto message. And this may be one of the few, if not the only time, I ever had moments of tension with him. I drafted a veto message, and he read it, and he said, it's not what I want. So I cranked it up a few notches and brought it back. It's not what I want. I think I had to write that thing 3 or 4 times before it had the passion, if you will, that he wanted in the veto message. And again, when he signed it, he called the legislative leaders into his office, and he said, I told you if you passed a death penalty, I was going to veto it. You've passed it. I'm going to veto it. And he pulled out the veto message and signed it. Yeah, and what he said was, he said, the problem with, I remember this now, it just came back to me. He looked at them. He said, the problem with each one of you is you never sent somebody to the electric chair. He said, I convicted 11 people, and I'm not going to see a 12th. Then when they left, he turned to me and said, yeah, I got 11 convictions, but I knew the Supreme Court was going to reverse them all.
I'm unclear on one thing. You said that you voted to uphold some executions with the majority. What prevented those executions from going forward?
Well, ultimately what prevented it was the two things. One was the amount of time it took to exhaust the appellate process on the federal side, and then the one conviction that had worked its way through not only direct appeal but post-conviction relief, which is a whole other story. And it went over into the federal courts under a habeas corpus proceeding. The U.S. District Court reversed us, and then the federal appellate courts refused to intervene. Ultimately, as you know, the legislature reversed field and abolished the death penalty.
Was that Robert Marshall, the one you just referred to?
Yes.
You delivered a couple of lectures, I guess during your time on the court, the Weintraub lecture and the Brennan lecture. One dealt with the Constitutional Convention of 1947. The other dealt with how some constitutional rights derive from state constitutions. Not all of them are in the federal Constitution. Right. Let's start with the first subject. Why did we have a 1947 Constitutional Convention? Why did we get a new Constitution then?
Well, there had been a movement that has gone back to the 30s for a new Constitution, and with particular reference to the judicial article of the Constitution. Our court system was that before the 47 Constitution was antiquated. As someone once said, New Jersey went from the worst court system in the country before the 47 Constitution to the best court system afterwards. So there had been some judicial reformers, the most prominent of whom was Arthur T. Vanderbilt. And he had lobbied for decades to get a new judicial article.
And who was he?
Well, he was an extraordinary person. He was a outstanding practitioner. He served as president of the American Bar. He was the dean of New York University Law School, and he was the Republican leader in Essex County at a time when Essex County was the dominant political county in the state. And so he worked long and hard to get a new judicial article. There were all kinds of entrenched interests that didn't want the pre-existing system changed, the most prominent of whom was Frank Hague. And
the boss of Hudson County.
Right. So there was an ongoing, but he was not the only one. And there was it took a long while to get the momentum to have the Constitution, a new Constitution adopted. It finally happened when Alfred Driscoll was governor, and he was another proponent of constitutional reform. So they finally got it through in 47.
You credit Vanderbilt and Driscoll with pushing that convention. Who else? Walter Edge? Any other governors that you can think of?
The various governors had signed on over the years in an attempt. One was Governor Edge. The other was Edison, I think, actually. But they just couldn't get the political clout to get it through until it all coalesced, as I say, in 47.
And you've already said we went from the worst to the best. So in your view, that new Constitution has well withstood the test of time?
Yes.
In all areas or just in the judicial area?
Well, I know the one I know the most about is the judicial article, but I think it's held up. We have a very strong chief executive. He has a line item veto, which is a powerful tool, and I think the Constitution has held up well.
How about in terms of the legislature? Did it do much to change the legislature?
Well, that has evolved over time, not only through the New Jersey Constitution, but also through federal constitutional mandates for change the actual makeup of under the one man, one vote decision.
We went from 21 senators, one per county, to 40 senators.
Right. Which
the Winbury versus Sanders?
Salisbury.
Salisbury.
Right.
Is that important?
Very important. And it.
What's the name of it again?
Winbury, W-I-N-B-E-R-R-Y versus Salisbury. I think it's S-A-L-S or I-S-B-U-R-Y, I think. And that was the one that really established the court's power, if you will, jurisdiction over the rules for the practice of law in New Jersey. And it had had a lengthy history in the Constitutional Convention and thereafter. But Vanderbilt, who had nursed this new judicial article and the new Constitution, did not want the legislature to make the rules over practice and procedure. And so in Winbury versus Salisbury, he came down with a decision which said that it's for the court. And the key phrase on which he relied was making that power subject to law. And the question was whether that meant subject to laws made by the legislature or by the court. And he said, well, it means by the court. That opinion engendered a lot of controversy. And one of the opponents of it was then state senator and later Governor Minor.
Why did Minor oppose that?
He thought the legislature should have the power to determine practice and procedure, as it does, in New York and in the federal government. And he thought that Vanderbilt had used some sleight of hand in getting the Winbury-Salisbury.
What county was Minor from?
He was from Warren.
Was he governor right after the convention? The Constitution
He was.
And he and Vanderbilt had what kind of a relationship?
Antagonistic.
Really?
Yes.
Had Vanderbilt played any role in Minor's election, do you recall?
I think Minor thought he did.
Minor was a Democrat.
Yes.
Vanderbilt was a Republican.
Yeah, and I don't know all the details of this, but Vanderbilt was very strict about judges not getting involved in politics, but I think there is some evidence that suggested that it may be all judges but Arthur T. Vanderbilt. I'm not sure about that.
Do you recall who ran against Minor for the Republicans?
First time? Oh, the first time it was Trost, Arthur Trost, and the second time it was Malcolm Forbes.
So Vanderbilt may have had at least a rooting interest in winning those elections for the Republicans.
Yeah, although I'm not so sure he weighed in at that level. It may have been at least so the story goes. It may have been at the primary level. I really shouldn't say too much about it because I don't know.
Did Vanderbilt come from the famous Vanderbilt family?
No, he was not related at all.
Let's talk about how state constitutions create separate rights from the federal Constitution. Is that true in all 50 states?
Yes, and the notion of state constitutions as creating fundamental rights greater than those in the U.S. Constitution really goes back to William Brennan. He, in the heyday of the Warren Court, he was very much part of the expansion, if you will, of constitutional rights. But when Chief Justice Warren retired and he was replaced, the U.S. Supreme Court started to take a different view of constitutional rights. Brennan remained committed to the notion of protecting those rights. So he, actually it was in a speech at the New Jersey State Bar Association, gave a talk urging the New Jersey court to take a more expansive view of its own constitution in protecting the rights of criminal defendants and in other areas. That became the basis for a Harvard Law Review article, which really precipitated the movement of state constitutions as separate sources of fundamental rights. The New Jersey court went on a path that was similar, comparable, parallel to that urged by Brennan in several decisions. search and seizure law. There were some search and seizure cases where the New Jersey court granted greater protection to a defendant than was accorded under the federal Constitution. The New Jersey court took a more expansive view of the woman's right to choose whether to have an abortion, and that movement, if you will, also obtained in other states. I don't know where it stands today, because for the last 11, 12 years I've been off the court, and I don't know if state courts are still advocating their constitutions as separate sources as vigorously as was done 20, 30 years ago.
Is there an opinion of yours that you want to talk about on the record?
Well, let's see. One of the opinions got a lot of play. It was called Department of Environmental Protection versus Ventron. In that the court ruled that a manufacturing facility that had polluted land was responsible, remained responsible, even though it wasn't the current owner. And I suppose there are some others out there that folks might find interesting.
Do you think that the trend against judicial activism is having an impact on the New Jersey courts?
I just don't know. I just don't know.
Let me ask you a question that I bet I asked you on television when we did an exit interview 11 years ago or thereabouts. Why did you decide to leave the court earlier than you had to? And how old were you?
I was, it was in 1999, so I would have been 67, I guess. And part of it was I wanted to have another career. I was afraid if I waited until I reached mandatory retirement age, that might not happen. And another concern was I wanted to make sure that my wife was a little more financially secure than she otherwise would have been. And I've been very fortunate, and I have been able to have a second career.
Practicing at Riker Danzig, a major firm in New Jersey?
Well, I think I don't know whether you'd call it practicing law. I do arbitrations and mediations, work with lawyers on appeal, and then until recently I've had some pro bono activities.
Can you give us a thumbnail view of how the court makes decisions on a day-to-day basis?
Well, when I interviewed law clerks, and they wanted to know how the New Jersey court worked, I always would explain it in terms of a 2-week cycle. That the first 2 days of the first week, Monday and Tuesday, would be argument days. But that week really began before those days, because in advance of oral argument, the justices, each justice would review the briefs, and we would have superb pieces of work from the law clerks. One law clerk writing a memo for the entire court called a confidential memo or a bench memo. And those would summarize the briefs, analyze the record, and give the court an outline of what was involved. And every member of the court would read those bench memos and the briefs before. So then you go down to argument, and you hear the arguments, at the end of which I know each day for 20 years I forced myself when I was home to write a memo that would tentatively decide the case. Now, I might change my mind, but I wanted to force myself into examining the case while it was fresh in my mind and reaching a result. Then,
Did all the justices do that, or was that just you?
I don't know whether everybody did it, but I did it. I wanted the discipline. I wanted to force myself to think about the case, as I say, while it was fresh in my mind. Then I would distribute those to my clerks, and I would often have questions. And they would be dictated right in the memo, and I would ask the clerks to look them up. Then during the balance of that week, we would go over petitions for certification, requests for the court to hear cases, motions, disciplinaries, and administrative matters. Then in the Tuesday of the second week, we would go down for the conference, where we would decide the cases, and the Chief Justice, if he was in the majority or she was in the majority, would assign the opinions. And then you come back and get to work on the opinion and start all over again with the next cycle.
What was Chief Justice Willence's role or style in bringing this all to a head each time?
Well, nobody ever had to doubt who was running the court. He was, I mentioned, an intense person, bright, committed, and he was very quick, like Brendan Byrne, to pick up on what were the dispositive issues. He was a hard-working guy who did a wonderful job.
And what's your comment on Deborah Poritz, his successor?
She had a different style, a little lower key, but again, very bright, very committed, and a delightful person to work with.
Do you have any concerns or worries about current trends in the New Jersey judiciary or in state government as a whole?
Nothing that I can think of. I think we have I think the court system remains sound, committed. I have a son-in-law who's now a Superior Court judge.
Really?
Yeah.
In what county?
He sits in Sussex.
How about ethics in government? Are you worried at all about that area?
It's always a concern, but I can't think of anything right off the top of my head that makes me any more concerned than I have been in the past.
Well, then let us get back to our main focus, and that's Brendan Byrne. How do you regard the 8 years during which he was governor of this state?
I think they were extraordinarily productive. We've talked about the pine lands. Another thing that was of great interest to him was the new penal code. And his 11 years as prosecutor left him with some concerns about the state of our criminal justice statutes.
He presided over a major reform of the penal code in 1979, as I recall.
Yes, yep. And I remember when I would sit down with him to go over the changes that were being worked on the penal code as proposed, as it worked its way through the legislature, and he was right on top of those issues all the time.
So how should we remember him, or how should future students of New Jersey government regard him?
Well, I think you would have to think of him as someone who was courageous, intelligent, dedicated, who really really loved New Jersey and wanted to make it a better place, and did.